Think the money sitting in your Indian bank account, your fixed deposits, or your NRE account has nothing to do with the IRS? It does. Millions of Indian Americans, H1B holders, and green card holders have accounts in India they've never reported to the US government. Not because they're hiding anything, but because nobody ever told them they had to. And the penalties for getting this wrong don't just hurt. They can wipe out everything you've saved in both countries. I understand what you are going through. I'm attorney Chad Silver, founder of Silver Tax Group. We work with US persons, citizens, green card holders, and visa holders who have foreign financial accounts they haven't reported to the IRS. And today, I want to walk you through exactly what Indian Americans get wrong about FBAR, because I get calls about this every single week. We're going to cover 4 things: which Indian accounts actually trigger the FBAR requirement, the mistakes Indian Americans make that turn a simple filing issue into a penalty disaster, what the IRS can actually take from you, and how to fix this before the IRS fixes it for you. Section 1, which accounts actually require FBAR reporting? The rule is straightforward. If you are a US person, a citizen, a green card holder, or an H1B holder who meets the substantial presence test, and your foreign financial accounts had a combined value exceeding $10,000 at any point during the year, you must file FinCEN Form 114. That's the FBAR. Here is where Indian Americans get caught off guard. It is not just your NRO savings account. NRE accounts and fixed deposits are reportable. Your Demat account holding Indian stocks, yes, it's reportable. Indian mutual funds, reportable as well, and potentially subject to additional PFIC rules that can create a separate tax nightmare entirely. But here is the one that surprises people the most every single time. If you have signature authority over your parents' Indian bank account, even if it's not your money, even if you've never touched it, that account may need to be reported on your FBAR. A lot of Indian families share account access. A lot of Indian Americans have no idea this counts. I worked with a client, we'll call him Raj. He came to the US on an H1B, got his green card, became a citizen. He had an NRE account, a couple of fixed deposits, and co-signing authority on his father's savings account back in Mumbai. He'd never filed FBAR once in 12 years. Not because he was hiding anything, because nobody, not his CPA, not his employer, not anyone, had ever told him he needed to. Section 2, the mistakes Indian Americans make. Mistake number 1, using a general CPA who doesn't know international tax law. Most Indian Americans use a CPA, someone in their community, someone who does a great job on their W-2 and their 1040. That CPA may never have asked about foreign accounts. If they didn't ask, they didn't file, and you assumed it was handled. It wasn't. Mistake number 2, thinking NRE accounts are exempt. NRE accounts are tax-free in India. The interest is not taxed there. But that is an Indian tax rule. It has nothing to do with US FBAR reporting. The FBAR requirement is based on whether the account exists and what the balance is. Tax treatment in India is completely irrelevant. Mistake number 3, forgetting about PPF or EPF, Public Provident Fund or Employee Provident Fund. These are government-backed retirement instruments in India. Whether they trigger FBAR is a gray area, but the IRS has signaled these accounts are reportable. If you have these and haven't reported them, that is a live risk. The bottom line on Section 2, if you have Indian financial accounts and you've never had a U.S. international tax attorney review your situation, you do not know your exposure, and not knowing is not protection. If any of this sounds familiar, call us now at 855-900-1040 or visit silvertaxgroup.com. We offer a confidential review, no obligation, and we'll tell you exactly what you're looking at and how to fix it. Section 3, what the IRS can actually take. For non-willful violations you didn't know, honest mistake, the penalty is up to $10,000 per account per year. If you have an NRE account, 2 fixed deposits, and a Demat account, that is 4 accounts, 5 years of non-filing, that is potentially $200,000 in penalties on accounts that may have had legitimate, already taxed money in them. For willful violations, where the IRS determines you knew about the requirement and chose not to file, the penalty jumps to the greater of $100,000 or 50% of the account balance per year. I had a client, we'll call him Vikram, green card holder, had an NRO account and FD his family had accumulated over 20 years. By the time we calculated his exposure for the unfiled years, he was looking at penalties that would have consumed the majority of what his family had saved over 2 decades. He came to us in time. We fixed it. But had he waited another year, the path back would have been significantly harder and more expensive. The longer these filings go uncorrected, the worse the penalties and the easier it is for the IRS to start building a willfulness case against you, even if you never intended to hide a single rupee. Section 4, how to fix it. If you have never filed FBAR and you are not currently under IRS audit or investigation, you have options. The IRS has programs specifically designed to bring people into compliance without destroying them financially. If you live in the US, the streamlined domestic offshore procedure may apply. You file 3 years of amended returns, 6 years of FBARs, and pay a 5% miscellaneous offshore penalty. That is painful, but it is dramatically better than the alternative. If you lived outside the US during the non-filing years, the streamlined foreign offshore procedure may apply, and in many cases, the penalty is zero. But here is the critical thing. Both programs are only available before the IRS opens an examination. The moment you're under audit, those doors close permanently. At Silver Tax Group, we evaluate your situation, we determine which program you qualify for, we build your compliance strategy, we implement it, and will defend it if necessary before the IRS. No guessing, no fear, just strong legal tax firepower on your side. Don't wait until the IRS comes knocking at your door. Call us at 855-900-1040 or visit silvertaxgroup.com for a confidential review today. If you have Indian accounts and you're not sure where you stand, that call could save you everything. I'm tax attorney Chad Silver. If this helped you, click like below and subscribe. I'll see you in the next one.